And all the medical marijuana certification is supposed to be, as the law was originally envisioned, was that a doctor defined as an osteopath or as a medical doctor would offer an opinion, which they're allowed to offer under the First Amendment, that a particular patient would likely receive benefit, be it palliative or otherwise, from the use of medical marijuana. That's it. An opinion. I mean, that's it. I mean, am I allowed to swear on your show?
Yes, please.
Okay, a fucking opinion. Every cop, prosecutor, judge, shit, everybody I fucking know has an opinion. They're like assholes. Everybody has one. But all the law said was that a doctor's allowed to actually offer an opinion, and that opinion will legally carry some weight. So the doctor can't get in trouble legally for offering an opinion. Now, the legislators...
As opposed to like writing a script or something like that is also what we mean, because there's no script. They're offering
There's no script. It's
right.
just an opinion. It's an opinion.
It's
like
to be a low standard.
It was supposed to be the doctor's expression of his or her First Amendment
belief, honest belief.
Belief. That's it. Nothing more, nothing less. Not a prescription, not a panacea, not a cure-all, not a full analysis with X-ray. It was supposed to be, look, I've examined the patient, I've talked to the patient, and I've done some analysis of the patient. I consider this relationship enough for me to form an opinion. That's it. Look, you and I, Mike, when we go to court, you know that cops, drivers, lay people, so this ordinary people who have any experience driving can come into court and can say, I saw 5 cars driving on Woodward between Maple and 14 Mile. And I know how fast cars normally travel on that road. And these 4, and I know that those cars normally travel the speed limit. And this car that I saw on this day was going faster than the speed limit. And you and I can object all day long and say, Your Honor, we object. That's speculation. And the judge is going to say, no, that's their opinion. They're allowed to express an opinion.
Which reminds me of my favorite quote. Reminds me of my favorite quote, which by Bob Dylan, which is, "You don't need a weatherman to know which way the wind blows." But go ahead,
there you go. Exactly. Smart. Better said than I said it. So here you got a doctor who's allowed to express his opinion, and all the law says is, hey, you got to do some examination or some, analysis. Not just you can't just look at the guy and look sideways and say, you know what I mean, like next. But you got to do something.
It's got to be bona fide.
So it's opinion. It's an opinion. And why does it say bona fide? Because we don't want you to be able to sit at your office and then, you have some doctor in Pakistan who's never met you, never reviewed a record of yours, never talked to someone that knows you, never reviewed a surrogate of yours, never talked to anybody who has any relationship to you at all. In other words, we don't want a mail order certification. It was just supposed to be something that gives the person a basis to offer an opinion. No different than if you came to court and offered an opinion like on speeding or on the weather or on whether or not, I saw her face was red, she was yelling and screaming, her voice was raised, she had her fist balled up. I formed the opinion that woman was mad.
A foundation.
You know what I mean?
Right.
That's it. It was just some foundation.
But we know that that's how it was perceived. I remember there was a point in time even where we discussed a doctor didn't even need to show up, but the card stood for the,
I still believe that should be the case. That the card should be,
But now we know. But listen, but we don't. Unfortunately, as lawyers, we have to not necessarily give advice on what we think it should be, but how we can protect our clients and give them the best advice. So, looking, I've kind of developed some thoughts on this, and I don't necessarily agree, and I agree with your...
And you qualify, regardless of what you think it should be, we're kind of stuck with the way it is.
Right. And we advise from a position of we're in court, and we see what's not working, and we have to move backwards from there and advise the community, our clients.
Well, there's also, remember, Mike, I said a second ago, there's also the distinction between when you're in court in a particular case and you're trying to advise your client, you're advising your client as that client's lawyer. Now, and that may be the same, but sometimes may be different than when you're looking as a whole, as an advocate, someone that's speaking to a community of people who aren't your client but who you want to try to inform. I mean, those sometimes are two different things, so.
That's true, but this is what I've drawn from all of the attention that has been brought to this particular issue, albeit I agree with your assessment on what the intent of that role was supposed to be. And what I'm hearing, and I know you hear as well, is the idea that, as it stands, this is allegedly, controlled one substance.
Right.
You get the equivalent of a recommendation or a script, but it's not. They give you something that allows you lawfully to use it, and there's very little contact, one would argue, whereas no other substance that was that quote-unquote dangerous would you ever be able to. These are the arguments that are there. You know what I mean?
Right.
The problem is, and this may happen to you sometimes, I wonder in the assessment that we're looking at for the doctor-patient is, you find sometimes the person qualifies, they have a condition, they go to they're a Vietnam veteran or they're a veteran and they're using the services at U of M hospital, but they've gotten certified by a doctor that certified them because the U of M hospital won't do it, and you ask them, who's your certifying doctor? And they say, I don't know. Does that make for a valid certification? I mean, they've got the condition. They've got 3 doctors that assisted them in getting their records and allowing it and continuing to monitor them, take blood, test them. This is one of the things that came up. One of the
I know.
And
I bet you try to do the best you can to defend those clients, those patients, don't you?
Well, that's what I'm saying. Do you think that the doctors that are doing the certifying need to maintain more of a relationship post-certification, or does it just really serve as the one-stop, get your card, and then move on? Is that doctor's role to be one that's more intertwined with the patient, and it could be limited to just supervising their cannabis use throughout the year, right? Taking feedback on the strains and the amount and the method of which one ingests, right? But not necessarily doing anything other than that. Would that be enough?
Well, I guess to answer your question, the answer is moving away from the ideal. Look, when a prospective client comes to me and says, what's your advice on how to go about getting certified? I try to give them the same advice. My advice is you have to take control of your doctor-patient relationship, which means that you get all your records together, order them. They're easy to order. From your past, medical treatment, get every record together, take it to to whomever you want to try to certify you. I would absolutely not let the doctor certify you one time if you had any control over it. Don't certify me today because that's not right. I want you to see me a couple times and create a file and look at an assessment. And then after you go back once or twice, and if the doctor certifies you, say, I want to follow up with you. The challenge is that I don't know that there are doctors out there doing that.
Right, that's what I'm saying. My thing is that I think that the patients have to start being a little bit more responsible for some of those things. Because the doctors.
That's kind of what I was saying, is that you have to take in, as a patient, if you want to make sure. Look, let's identify why, for your listeners, why we're saying this. In a perfect world, there would be some invisible shield, a bubble, that would, once you're a patient and you're a qualifying registered patient, that the bubble would be like an invisible protective shield that would, go with you wherever you go and will protect you from any legal problem. That's not the case, though. The legal problems that come from being a cannabis user or a cannabis caregiver are that the police may visit you or stop you. And then you have to hope that whatever you have in place at that point in time will satisfy those particular police officers, the particular prosecutor that may be involved in your case, the particular judge that may preside over the case. And so that means that all the stuff that your patients do, your clients, your listeners might do, before they're stopped by the police, because they're not going to be stopped by the cops when you're standing next to them, Mike, right? they're going to be stopped on their own, in their own lives, somewhere in their own, as they go about their own lives. And when they're stopped by a police officer, freeze that tape in that moment of time and look backwards. And whatever they've done up to that point is going to have to be meaningful in order to give you, as their lawyer, any chance to get them out of this mess, whether it's at the scene, whether it's if they're arrested, or whether it's in court.
Yeah,
that's why you and I are saying that patients have to take control, because we're not there when they're arrested. We don't have any control over when a patient gets arrested. So all of this means everything we're talking about is important for how do you protect yourself if, God forbid, you get arrested and charged with the crime. What tools are you going to put in your lawyer's hands?
That's the only reason why a person gets their card. You don't get a card to show your neighbor. You get your card so you can defend yourself in court.
So now we've said exactly what we need to say, which is that while you're going about your life, think of the worst cannabis opponent you can think of. Think of the most hostile judge, and you have to build your medical cannabis profile to that judge. Go see the doctor a few times. Go build up your medical records. Go see a couple specialists. Get files. Follow up after you get your certification so that there's a subsequent history. So God forbid you are arrested or charged with a crime, when you contact Mike Komorn and say, Mike, I got arrested and I have a criminal case, you come to the office and Mike's going to say, well, let's go through the things what does your patient file look like? Well, it's thick. I saw my certifying doctor 3 times before he certified me. I've seen him 3 times after. I went and got every medical record I ever had, dating back to when I was 18 years old, and gave it to him. Those are all things that
they're not even getting that in front of the judge a lot of times.
No, but the reason why they don't is because a lot of times throughout the state and other areas there is not access to the doctors. And the access that they have is when somebody comes into that town or area for that moment in time, and that's and they have every condition that they would have. They have all the medical records, but it's just a one time. And when they get arrested, you ask them, "Who's your doctor?" They say, "I don't know. It was the guy that was at the hotel." But that doesn't. The question is, does that make for a missing certification?
Well, I mean, if you're asking me, would I still argue that case on behalf of that patient? The answer is yeah. Look, I'm going to tell you this. I mean, I'm going to argue that if somebody takes medical records, if a client takes medical records, to let's say that a client gives medical records to a physician's assistant, and they take it to the doctor. The doctor looks it over and talks to the client on the phone. I mean, are you asking me personally if I feel? Excuse me. That suffices. I mean, I'm okay. Personally, I'm okay with that. The courts aren't necessarily
right. Exactly. That's my point. See, this is what my thought on it is this. We all agree that we shouldn't even have to be talking about this.
I mean, most of the cases that I've seen facts are not even coming up.
But but in some areas, it's like you're a lawyer. You walk into court, you say, my name is such and such. They say, prove it. Here's my medical marijuana card. They say, who's your doctor? That's what lawyers do. If you're a prosecutor, if you're a defense lawyer, we're seeking. They're supposed to seek justice, not just trying to.
Our point is this. That when the police officer stops you and you hand the cop a driver's license, they don't say, Michael Komorn. I don't believe it.
But that's not the point. Here's the point. The point is that you get your card, they're not honoring it, then you get into court, and they want to look behind it. And really, as we've found, the perception in a lot of areas is that anyone can get a card for any reason. It's not a big deal. I'm not opposed to that, okay? But it waters down the value of it. Now, I don't blame the medical marijuana community. They've done nothing wrong. I think that what you've seen is some doctors not really providing any services beyond just to show up, But again, they're also arguably courageous and they're coming forward and providing.
I think that there are some doctors that are even doing worse than that. I think there are some doctors that are signing certifications and then when they're asked to come to court, may even be, backing out.